In a major Supreme Court ruling today involving a San Diego case, the rights of police to search a person's cell phone with a warrant. The court ruled unanimously it's unconstitutional. As 10 News reporter Michael Chen found out, experts believe the case could set the stage for other decisions involving privacy in the digital age.
The question before the High Court: when can law enforcement search your phone? The Supreme Court's answer,
when I heard that, I said, thank you, Jesus.
left a local mother jubilant.
Justice. Thank God, justice.
And attorney Pat Ford, who brought the case all the way to the High Court, ecstatic.
It's a huge victory for anyone who values privacy.
In a unanimous ruling, the court said police must have a search warrant to go through a cell phone of a person they've arrested. The San Diego case involved Bridget Murphy's son, David Riley. A 2009 traffic stop led to the discovery of 2 loaded guns and a cell phone search. Ford says several photos and videos linked Riley to a gang member involved in a local shooting, which led to a 15-year attempted murder conviction despite no direct evidence connecting Riley to the shooting. Though police are typically allowed to go through your belongings upon arrest, the court ruled the search of Riley's phone was unconstitutional.
We've got our whole lives on our cell phones, so much data, so many pictures, so many emails, and to let the police go through that without a warrant, the Supreme Court said, is just incompatible with the Fourth Amendment.
The court ruled the one exception is an emergency situation like an active kidnapping case.
The state of California also raised concerns that criminals could remotely wipe out a cell phone's data, but cell phones can be turned off. The suspect typically would be in custody, and the Supreme Court largely dismissed that concern.
Law professor Alex Kreitz says the unanimous message sent by the court likely signals the court will take a close look at privacy issues in the digital age. Another issue they could soon look at: the sharing of your GPS data.
And back to the San Diego case, Riley's conviction was not overturned. A lower court in San Diego will make that decision after weighing how strong the case was without that cell phone evidence.
And you mentioned this is without a warrant, but in legal rulings like this, we tend to think of hardened criminals. Is that the case in this?
Well, under a lot of traffic situations, citations, you're technically under arrest, and the High Court today ruled that it makes no sense to allow those cell phone searches for a traffic citation.
Thank you, Michael.